Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Today, our video is dedicated to Lucy Letby. We will look at the latest events that surround this case, and in particular, the latest demands by a group of experts into either delaying or altering the terms of the Thirlwall Inquiry, which is due to start next week. Let's start by contextualizing the events. Given the alleged heinous crimes committed against the most vulnerable beings, namely fragile and very sick premature babies, by someone who was entrusted with their care by the system and by the parents, and with no clear motive for these actions, it is unsurprising that the trial of Lucy Letby has sparked division not only in the UK, but across the globe. Some call for her to rot in hell, while others view her as a scapegoat used to divert attention from the failing of the NHS. We have provided a timeline into Ms. Letby's case in our video Lucy Letby, Court of Appeal or Super Expert, which you can find linked in the description below. Significant criticism of the evidence used to convict Lucy Letby, particularly related to medical and statistical data, began emerging during the trial and intensified following the retrial of baby K and the lifting of the Court of Appeal's embargo on the case. These criticisms have raised serious doubts about whether Ms. Letby received a fair trial, with some suggesting that she could potentially be innocent. The latest criticism of the evidence in Lucy Letby's trial, adding to an already growing list of concerns, involves errors in the door swipe data presented during the initial trial. The data which tracked when medical staff entered or exited the neonatal unit and which was used by the prosecution to place Ms. Letby on her own whilst allegedly committing these crimes, was found to be incorrectly labelled. So it appears that she was not on her own on those crucial moments after all. The CPS admitted the mistake, but maintained that it did not significantly impact the overall prosecution, as the case involved multiple strands of evidence. They also said that in any event, the error was corrected during the June retrial, which nonetheless resulted in another conviction. On the other hand, Lucy Letby continues to protest her innocence, which she openly displayed as she was ushered out of the courtroom after her sentencing hearing following her June retrial. We also understand that she has applied for leave to appeal against her last conviction, and that this application is pending. Just yesterday, The Guardian published further news surrounding Lucy Letby's so-called confession note, in which the prosecution emphasized sentences such as "I'm evil, I did this." From the trial, we learned from Ms. Letby categorically disputing that these were admissions of guilt. And quite the contrary, these were notes aimed to confront her frustration at the way she was made to feel, and which even made her question her nurse's practices and skills. It now emerges from this article that the Countess of Chester Hospital's own head of occupational health and well-being, Catherine de Berger, mentioned several times in Lucy Letby's notes, encouraged Letby to write down her feelings as a way of coping with extreme stress. This was as part of counselling which she received soon after having been suspended from her duty following the detection of the cluster of deaths at the Countess of Chester Hospital. The growing concerns have not been quieted by 2 trials resulting in convictions and a failed application for permission to appeal. Instead, they have grown significantly and persistently. These doubts are not being raised by individuals disillusioned with the criminal justice system. Rather, they are primarily coming from the medical and scientific communities. Recently, a group of 19 registered and retired nurses and medical and healthcare professionals have anonymously, fearing career repercussions, written to Prime Minister Keir Starmer. The letter, signed 19 concerned nurses, and which can be found on the Science on Trial webpage, demands a full forensic review of the evidence used in Lucy Letby's trial. The letter states, amongst others, many of us have carefully studied the evidence presented in court, with some of us attending the court hearings in person. But all of us are worried that this conviction is unsafe, and as a result, we and many of our colleagues are now terrified to continue working in the NHS, as we believe that next time it could be one of us who is blamed for a failing system. Among their concerns, they highlight the fact that the jury was not presented with the 2016 Royal College of Pediatrics and Child Health report, which was commissioned following the discovery of the spike in deaths at the Countess of Chester Hospital, the failure to adhere to established protocols for blood sampling in the insulin cases, misrepresentation of the actual health conditions of the babies, inadequate exploration of alternative causes of death. This follows media reports in which some nurses revealed that they were told by NHS trusts not to get involved in this case. A nurse who trained with Letby at the Countess of Chester Hospital told The Telegraph that she was asked to be a character witness by the defence, but her NHS trust advised her against getting involved. A second nurse and a registrar who still work in the hospital also said that they had been instructed by NHS bosses not to talk about the case, despite previously voicing their support for Letby. Dr. Svelena Dimitrova, a consultant neonatologist, interviewed as part of the Channel 5 documentary aired on the 5th of August 2024, warned of an endemic and unprecedented wave of resignations amongst nurses who fear being scapegoated by the system. In the meantime, it has recently emerged that 24 experts, including some of the UK's leading neonatal experts and professors of statistics, wrote to the government for the attention of the Health Secretary and the Justice Secretary respectively, demanding that the Thirlwall Inquiry, due to start on the 10th of September 2024, be either delayed or its terms of reference altered. If you recall, we discussed the inquiry's terms of reference in our video Lucy Letby Inquiry, How Far Will It Go?, which you can find linked in the description below. At the time, we were concerned about the statement made that the inquiry will not review the jury's verdicts in Ms. Letby's trials. In fact, on the contrary, the terms of reference were designed to take into full account the jury's verdicts. At the time, we questioned whether the inquiry should distance itself from the criminal court's findings and argued that focusing solely on Letby could obscure broader malpractice issues. We highlighted how the strict adversarial rules of a criminal trial limit its scope, whereas inquiries are more flexible, open and truth-seeking processes. If medical malpractice played a role, we argued that an independent inquiry, separate from the court's conclusion, would be more effective in either dispelling or properly addressing any doubts of broader malpractice to ensure that lessons are properly learned. Our concerns appear to be shared by this group of experts. In a BBC article of the 20th of August 2024, it was reported that the group said, making the natural assumption following the convictions that Letby was a murderer may lead to a failure in understanding and examining alternative, potentially complex causes for the deaths, thus missing important lessons. Possible negligent deaths that were presumed to be murders could result in an incomplete investigation of the management response to the crisis. The Guardian reported that the group makes two proposals. The first is a temporary pause in the public inquiry to allow for further investigation and to hear wider professional concerns. The second is to change its terms of reference to enable a broader examination of the potential factors contributing to the increased neonatal deaths without the presumption of criminal intent. The signatories, who describe themselves collectively as a diverse group of doctors, nurses and scientists, and who have independently examined the Letby case, stressed they were not associated with Ms. Letby or her defense, nor were they driven by emotional reactions to the case. They said our approach is rooted in scientific analysis and concern for systemic issues within the healthcare and the justice system. While we acknowledge the gravity of the convictions against Ms. Letby, our focus is on the broader implications for patient safety, healthcare management, and the potential for miscarriages of justice in complex medical cases. We believe that legal systems are particularly vulnerable to errors when dealing with intricate scientific evidence, especially in cases involving statistical anomalies in healthcare settings and the complex physiology of neonates. However, it is understood that the inquiry will commence next week as planned, will not be broadcast, and that the terms of reference will not be altered. If the inquiry is to accept the case as emerged from the criminal trial, according to which Letby acted as a cunning murderer, adopting different methods to avoid detection, one may even question the need for such an inquiry. How could management be blamed for failing to spot such carefully planned crimes that even misled pathologists and coroners who initially found no foul play in postmortems? One can argue that a more practical and cost-effective solution would simply be the installation of CCTV in neonatal units, monitored daily to ensure no harm is done. We will have to rely on hearings transcripts experts as and when they will be published on the Thirlwall website to learn more about this inquiry, and only time will tell whether this expensive exercise will in the end be worthwhile for all those involved and for those who will in future may benefit from any recommendations which may follow. In our opinion, the concerns raised by the group of the 24 experts highlight significant questions about the scope and effectiveness of the upcoming Thirlwall Inquiry and argue that a more flexible, independent review might better address broader systemic issues in healthcare and justice. Their perspective suggests that focusing solely on Lucy Letby's individual actions might obscure deeper, potentially critical issues relating to medical malpractice and institutional failures. The challenge is therefore in balancing the need for a thorough investigation of the broader systemic problems with the constraints of adhering strictly to the terms of reference that do not reconsider the jury's verdict. As the inquiry progresses, its ability to address these concerns will be crucial in determining the overall value and impact. Only time will tell whether this approach will fully address the complex questions and potential lessons surrounding this case. This concludes our session today. I hope you have found it informative, and if so, please do like this video and subscribe to our channel to help us with our mission to highlight the shortcomings of our criminal justice system. Also, join the debate and influence the content of this channel by becoming a member of our community via our networking hub at spokeninjustice.net. Join us again next week as we sit and rise in this unique trial.